Hello, everyone, and thank you for joining us for today's webinar to discuss remote working in times of COVID. My name is Annie, and I will be facilitating this session for you. So today's presentation will be given by a set of panelists who are all lawyers in different Jus Laboris firms. We have lawyers from Russia, Poland, and all the Baltic countries joining our panel today. Okay, that's it from me. I will now hand over to our first speaker, Toms Sulmanis from Latvia. Go ahead, Toms. You are welcome to start.
Hello, everyone. So maybe in the beginning, let's do a quick round of introductions who we are here presenting today. So my name is Toms Sulmanis, and I'm from Cobalt Riga office.
Hi, hello, my name is Irina Anyukhina, and I work in Moscow, Jus Laboris, Russia, Al-Rud law firm.
Hello, I'm Daria Zhuk, Cobalt, Belarus. Happy to be with you today.
Hello, my name is Hailey Habu, and I'm from the Cobalt Tallinn office, Estonia.
Hello, my name is Jovita Valatkaite, and I'm from Cobalt office in Vilnius, Lithuania.
Hi, my name is Adita Yagivo, and I work in Warsaw in Raczkowski's office.
Okay, so let's move on with the presentation. So today we're going to cover three main topics. So first one is going to be general issues about remote work. Second will be health and safety matters. And third one will be privacy, confidentiality, and working time issues. So we can move on to the first topic. So starting with the general issues for Latvia. So first thing you have to always bear in mind is that workplace is an essential part of employment contract. So unless remote work is provided in the employment contract, it's not possible for the employer to force employees to work from home and vice versa. So employees cannot demand that they want to work from home. So if you are going to introduce work from home regularly, so we highly advise to include respective amendments in the employment contracts. That's one thing. And the other thing to remember is that even if you have it introduced in the employment contracts, you have to decide for yourself what kind of arrangement it will be, whether it will be an option or a benefit for the employee, or it will be like a cost saving for employer that for a certain amount of time you are demanding the employees to work from home. So that's also an issue to consider, and there are two possibilities. You can include that into the employment contract as well, or probably even better would be to adopt separate policies on remote work where these issues could be described in more detail. So that's it for Latvia. Then passing over to Irina.
Thank you, Toms. In Russia, we make distinction apparently between remote work and work from home, because both these type of work arrangements are regulated by law. So work from home apparently is mainly used when goods and products may be manually manufactured at home, and participation of the family members is in the work process is allowed. So this type of arrangements are often used to hire disabled people. Currently, this is not the case that this type of arrangement is used during the COVID-19 situation. So remote work means that there is no fixed place of, fixed workplace. Employees are free to choose the place from where they will be telecommunicated. It's up to them to decide. The key point is use of telecommunications means and internet when they perform their labor duties. So terms of employment should not be less favorable than those terms of employment of office employees or other employees, but in the agreement for the remote work, there could be specific conditions additionally included for this particular type of arrangement. So remote employees should use the equipment, software, and security tools and other means which are provided by the employer or recommended by the employer. Costs of use of personal equipment will be compensated in the way and amounts which are foreseen in the employment agreement for the remote work. Interestingly, combination of remote and office work in Russia during one and the same period of time is not possible. However, because of the COVID-19 situation, the draft law is now passing the readings in the parliament, and we do hope that it will be adopted soon, providing for new regulation and new possibilities. During the first lockdown, as well as nowadays, we see the requirements of the authorities to have the employees still communicating. Currently, the mayor of Moscow has passed a decree prescribing that not less than 30% of the employer's headcount should be switched to remote work. I have to mention one recommendation, which is to be kept in mind by the employers. There is a practical solution when CEOs of the companies pass formal decision with the list of people who will be switched to remote work. But this is not at all times sufficient, because by labor code, it is necessary to have amending agreement to exist in terms of employment. And that's why this is not to be fully neglected. So the recommendation is to have the employment agreements in place. And this is it for Russia, and I turn it over to Haley, Estonia.
Hello, thank you. In Estonia, we haven't really had a full lockdown, so performing work from home has never been mandatory during the entire epidemic. And the general principle of the Estonian Employment Contract Act is that if an employee is expected to work remotely from home or for other location, then this needs to be specifically agreed upon in the employment contract. So it is subject to the consent of the employee. It may be agreed that remote work is optional, so that the employee is free to decide whether to do it or attend the office. Or it could also be partial, so a couple of days per week, for example, that the employee only joins the office for meetings or specific reasons. The terms of the remote work can be agreed upon in the employment contract or a separate policy made by the employer. So the law is not that strict about agreeing all the specifics. And some of the problems that we see in practice is that employees sometimes wish to work from home, but the employers are reluctant to accept such arrangements. Or as relates to this pandemic situation, that the employees who have been finally given the chance to work from home do not wish to return to the office. So these are also issues that can be solved by the agreement of the parties. I'm turning to Jovita for further comments on Lithuania.
Yes, thank you. So the law in Lithuania actually provides 3 situations where work from home is mandatory in some cases, and actually optional. So first of all, if extreme situation or quarantine has been established in the country, and if it is not possible to organize work safely in the workplace, the employers must send the employees to work from home. Also, that is the case where one of the employees may cause threat to other employees because he may be infected or he may have a disease. The law actually does not specify whether it's COVID-19 or another type of disease. Now, a specific set of employees, So such as employees who are pregnant, have recently given birth or are breastfeeding, have children, have a specific health condition, may demand the employer to be working from home. So the employer can actually state that work from home is not possible only if that would bring extreme expenses and would not be proportionate to the request of the employee. And if not that is not the case, then the employer should organize work from home at least 1/5 of the employee's time. So 1 day out of every 5 days, the employee who belongs to those specific groups should be working from home. And then the rest of the cases are actually optional. So then the employer and the employee can decide whether work from home should be organized or not. And also it is highly, highly recommended to have specific rules which regulate working from home, because the law actually provides some very specific obligations that the employer should comply with. And I'm hoping we will speak about those obligations further along in the presentation. And now I will pass the word on to Edita from Poland.
Thank you, Vita. When it comes to Polish regulations, we currently have 3 types of remote work. Namely, we have telework, which is regulated in the labor code. This type of work should be regularly performed outside of the office, for example, 3 days per week. And it must be performed by use of means of electronic communication. And also the results of work should be provided to employer through such means. First, for example, an employee sewing masks and sending them to employer by a regular post would not be treated as a teleworker. Telework is quite formalized. As a rule, it requires agreement with unions or adoption of a regulation, which must be consulted with employees' representatives. And also a telework contract should be signed. In practice, due to those formalities, telework is rather rarely used by employers in Poland. We also have, as of March this year, we have a special type of remote work regulated in the Anti-COVID Act. It can be introduced based on employer's order. It is ordered in case if the employer wants to prevent the spread of COVID. In fact, it's the only type of remote work that can be compelled. It is also performed regularly outside of the office, however, only for a specified period of time. This period of time should be specified in the employer's order. Also, the rules of such remote work should be regulated in such order. And the third type is a kind of a standard remote work, including home office. It's not regulated in any act, but it's customarily used by employers. It is a type of work that should be exceptionally performed outside of the office, for example, 2 days in a month, and it is applied on employees' request. Rules of such remote work are also usually regulated in some internal policies. It was treated as a benefit by employers and by the employees. However, during pandemic, it was also used regularly to prevent the spread of the virus. So there was no formal order of the employer. However, employees simply requested work from home for certain periods and performed it based on the policies which have already been in place. So as you can see, none of the types of remote work in Poland is mandatory. However, based on the Anti-COVID Act, in order to prevent the spread of the virus, the employer can introduce remote work for specified period of time. And that would be all for Poland. Daria, would you continue?
Thank you, Edita. Yes. If to speak about Belarus, we have quite a general regulation on remote work, and surely it's in trend now in Belarus, even despite this fact that Belarus is not an official quarantine or we don't have any special act that would trigger the mandatory remote work regime. And as in our neighboring countries, the remote work is generally regulated, for instance, by law, by labor code from January this year. And our approaches are quite similar to our neighbors. So I would not repeat this insight that my colleagues have been already given. So maybe I would also emphasize that in Belarus, the remote work requires the consent of the employee. So it could be formalized either by a separate additional agreement to the already existed employment agreement, or can be done via newly concluded employment agreement. Remote work can be introduced to those employees whose labor functions involve certain independence in their work performance and possibility to present its results via telecom means of communication. Sometimes remote work is also connected to change of essential working conditions. For instance, when employer changes the working time or even salary arrangements, then these all conditions shall be realized via changing of essential conditions, also require employees' consent, but if employee refuses to switch into remote work and other newly introduced condition, then he can be dismissed subject to 2 weeks severance payment. In case if not other essential conditions are changed, so the employee may refuse but could not be dismissed. So it all from my side, and we are ready to move to another section, health and safety. So Toms, please.
Yes, thank you, Daria. So second round for Latvia. So as in many other countries, in Latvia, employers have a general obligation to ensure safe and healthy working conditions. And although it's not expressly defined, this includes also mental health of employees. And what's interesting that in Latvia on July this year, amendments were introduced into the labor safety law, which finally define remote work. And there are certain special conditions introduced. For example, employees who are working remotely are obliged to cooperate with the employers in assessment of working environment risks. And what is also interesting that there are 2 options how you can arrange the assessment. So if you have only one workplace remotely, then you have to perform assessment for that particular workplace. But if you have several remote workplaces, then you don't have to assess each and every of those workplaces, but just the general type of work, for example, work with a computer. And I think that's a very good option how to work around those stringent requirements and maybe a little bit make it easier for employers. And another novelty is that there are currently amendments to the labor law in the parliament. They are about to be adopted in the coming months, and also the labor law will finally define remote work. And it will be expressly allowed to agree between employer and the employee that all expenses related to remote work can be covered also by the employee. So that's a very welcome amendment and would clear very many problems and disagreements between the parties. That's it for Latvia. Irina?
Thank you, Toms. In Russia, yes, same as in Latvia, in case of work from office, employers should ensure all safe conditions of work, both during normal life and with even more attention and care during these days, given all this disinfection, social distances, masks and gloves, and so on. In Russia, if an employee visiting the office do not follow these rules, this may be regarded as non-compliance with safety requirements, and may be a ground for a disciplinary action against the employee. Fines in Russia were increased for non-compliance, both for the company and for corporate officials, company officials who are in charge of ensuring the health and safety rules. Now, when it comes to remote workplaces, since there is no workplace, in fact, and this is a place beyond the control of the employer. So the companies, the employers have rather limited set of obligations with respect to health and safety. Major liabilities, they are by general rule include the need to investigate injuries and accidents at work, provide compulsory social insurance of the employees working remotely against industrial accidents and occupational diseases, checking whether the prescriptions of federal authorities are followed and implemented. However, if the employer provides to the employee or recommends the employee to use particular equipment, particular tools, particular software, the employer should inform the employee of the health and safety rules of work with such equipment. Same as in Latvia, mental health is not specifically addressed in Russian legislation, but is covered by this general health and safety regulation. Depression, stress at work, mental health, they are also addressed by the employers, I would say, as part of corporate HR policies and best practices. So currently it is more and more the practice to provide psychological support, to coach employees working remotely, arrange relaxing corporate or social events like yoga courses online, team games, or tournaments. This is it for Russia, and let's switch to Haley, Estonia.
And in Estonia, the employer, as well as in Latvia and Russia, remains liable for the health and safety of the employees, regardless of whether the employees perform their work from the office, employer's location, or remotely from their own homes. So this means that the employer must assess the working environment risks present in the working environment, even if such working environment is the employee's home. So the most relevant risks that must be assessed are the same: the physical, psychosocial hazards, as well as physiological. And the employer is also required to apply measures in order to mitigate such risks. So in practice, it can be a bit of an issue of how an employer is supposed to even get access to their employees' homes or other remote working locations to perform this. And the local labor inspectorate has suggested to use assessment questionnaires to request the employees themselves to provide information, as well as video connections and recordings to understand what the risks may be and whether the workstation has been set up properly. So that the employers can do that, but obviously, since the occupational risks for a short period remote work are not that high, then I can't really say it's a prevalent practice. However, I think that the trend is definitely going towards more energy being put into this as the remote work becomes more dominant. And under the law, the employer should also, of course, cover all the expenses relating to setting up the workstation, and there are no exceptions for remote work. So the employer should provide the necessary work equipment, but in practice, it is usual that the employee still purchase their own furniture for their home offices, and the employers are not required to cover such investments. Passing on to Jovita.
Right, so in Lithuania, the employer still remains and has the obligations to ensure safety and healthy work conditions, even though the employee is working from home. So perhaps this is contrary to Russia's situation. And this obligation actually includes mental health, although it is not specifically mentioned in the law. Now, the employer has the obligation to perform professional risk assessment, and contrary to Latvia, this includes every single location where the employee is working. So as you can imagine, it's quite an administrative burden. So for this reason, actually, the law provides an alternative. If the employer cannot check every single remote work location, then the employer should instruct the employees to perform their own professional risk assessment. And that can be done in form of questionnaires or similar tools. When it comes to expenses which employer may or may not cover, then we usually recommend 5 steps. So first of all, redefine the list of work tools that are indispensable for the employee. Assess both physical tools such as computers, desks, and chairs, and online tools such as e-signature or some specific access to a specific system. Then provide the indispensable tools so that work can be done remotely, safely, and actually adequately. Train the employees to use the tools if they have not been trained to do that, and provide a manual or manufacturer's instruction on how the tools should be used and maintained, so that the employee does not start to repair his own computer if there is an issue with it. And then actually consider insuring the tools, because the law actually states that the employer should provide insurance for the tools. So these are the basic rules regarding health and safety in Lithuania. And now let's go back to Poland.
Thanks, Jovita. Well, when it comes to health and safety during remote work in Poland, we also have some general obligations that apply to all types of remote work. For example, an obligation to ensure that the workstation meets all health and safety requirements, or as in other countries, an obligation to assess working environment risks and obligation to inform employee about them. Health and safety obligations are slightly modified only in case of telework done at home. In such a case, the employer is not obliged to care for the state of the buildings and the room in which the work is performed, and it's not obligated to ensure appropriate hygienic and sanitary facilities. And this is due to the fact that performance of these obligations may not be possible when employee is working from home. In practice, health and safety is assured in all types of remote work by providing the employee with the list of applicable health and safety requirements and asking him to confirm in a questionnaire that his workplace meets all those listed health and safety requirements. Sometimes employees also provide a photography of the place where they are working at home, and this is assessed by a health and safety specialist. When it comes to the costs of remote work, the general rule is that employers should cover all expenses related to performance of remote work and provide work equipment. In case of telework, it is also expressly mentioned in the labor code that in case if an employee is using his own equipment, he should receive a cash equivalent. In case of remote work, which is ordered due to COVID, an employee can also use his own tools on condition that the safety of information is ensured. In this case, no cash equivalent is expressly required, expressly mentioned in the law. As a rule, in practice, employers provide basic equipment like laptop and mobile phone, and employees cover other expenses. For example, similarly as in Estonia, they buy furniture, they pay for electricity. Sometimes employers cover costs of internet connection. I think that's all for Poland. Daria?
Thank you, Edita. Yeah, I'll continue on Belarusian side. I would also support the position of my colleagues that health and safety obligations are not much specified in our legislation, and it more goes to the general obligation on employers to ensure safe and healthy working conditions. And the other requirement in Belarus that employers shall formalize in written employees with such requirements relating to the labor protection. If we speak about mental health, it is also not legally defined or expressly included in our law, but as a rule, employers voluntarily decide on such measures. And surely it more relates to employee-friendly HR environment, and companies here can be as much creative as they can. In terms of the work tools, our law again is a very general in this aspect, and it said that all these arrangements may be agreed by the parties in the employment contract. For instance, employer may provide the work tools himself, like hardware or software, or may recommend the employee to use his own tools, give some instructions how to use them, even employee may choose these work tools without any formal recommendations or instructions from the employer's side. So these arrangements may be agreed by the parties mutually, depending on the work functions, working regime, and so on and so forth. There is no any mandatory obligation on employer to reimburse any expenses. These issues again could be agreed mutually by the parties. The employment contract may contain the amount, procedure, and conditions for payment of compensation for use of the employee's owned or rented work equipment or tools, or other expenses like electricity costs or internet connection costs. We know from our clients that in practice sometimes they really reimburse some additional costs for the employees, especially for internet connection. So this is all from Belarusian side, and let's move to privacy issues.
Okay, so then the final topic of today for Latvian. So obviously, as you can imagine, there are a number of challenges related to confidentiality when working remotely. And what we always recommend for employers to do is to adopt detailed rules and policies regarding confidentiality issues in case of remote work. And it's important not to include those in employment contract amendments, but in separate policies so that they can be amended as necessary later on. So the usual topics to be covered by such policy are not printing of documents or so-called clean desk policy, not leaving the computer unattended, using secure internet connection rather than free hotspots in cafes, and similar issues. Then moving on to recording of working time. So we have this European Court judgment, and also according to Latvian law, employers are obliged to record each and every hour worked by the employee, including overtime during holidays and similar. So there could also be some challenges in case of remote work in such situations. So obviously we don't recommend to make video surveillance of the employees, because that would be too excessive intrusion into employees' privacy, but rather than to use various other solutions depending on the particular position. For example, special time recording software, Excel sheets, or if that is not practical, you can simply assume that the employee has worked all 8 hours during the working day. There could be additional challenges in case the remote work is combined with the flexible working time. And for those situations, we recommend to provide in the policies that certain provisions so that overtime can be avoided and also night work can be avoided because otherwise there could be significant additional expenses for employers. That's all for Latvia. Moving on to Irina.
Yes, same as in Latvia, protection of confidentiality and data and privacy issues, these are the key challenges for employers. The risks of unauthorized access, disclosures, and leakages, especially at public places, not only at home, they are significantly higher than usually. Now, I would say more than ever before, IT measures are largely used, including encryption, access codes, restriction of access from other technical devices through software pre-installed on corporate devices. This means, however, they are not sufficient from legal perspective, and they should be combined with corporate policies and regulations adopted in the company. Commercial secrecy regime should be introduced in the company based on the local policy. Protection of confidential information, data protection and data processing policies. These policies are the background for legal action against non-compliance with these policies. It is also important to keep in mind in Russia that it is not sufficient just to introduce the policy. There should be evidences that they are, in fact, implemented at operational levels. Commercial secrecy regime in Russia also necessitates actual means of protection and accentuates the need to combine policies, IT means, and more and more often leakage reporting on the corporate level. If such measures are in place, employer is able to hold an employee accountable, liable for leakage or unauthorized disclosure. And I have to mention that in Russia, under Russian Labor Code, disclosure of confidential information, commercial secret, personal data, this is a special ground for dismissal. There are cases of dismissals based on unauthorized disclosures in Russian courts. Normally, they are decided in favor of the employer. Recording of time during remote work may be a burden for the employer because this is the liability of the employer to take care of the way the recording of time is done. So this is generally should be done based on terms of employment agreement or on corporate policy. In this case, working time may be recorded in the course of monitoring the online activities of the employees. Of course, if there is a workplace monitoring policy in the company, acknowledged, made known to the employees. So data about online activities may be collected by IT utilities pre-installed on the pre-installed software. Again, it is quite interesting to mention that remote employee, in fact, may not be dismissed on the ground of absenteeism, absence from workplace, because the concept is that there is no workplace, so this ground is not relevant for the remote employees. That's why, by the way, the legislation in Russia allows to agree special terms in the employment agreement with the remote employee of termination of the remote employment agreement, special grounds for that. So this is very beneficial for the employers and should be kept in mind. The reporting obligations, same, may be included in the employment agreement with the remote employee. And this is quite important because since absenteeism is not the ground, it is necessary to include reporting obligations to have certain control over the activities of the employee working remotely. And now the floor is to Haley, Estonia.
The situation in Estonia, I guess, is very similar to the one in Latvia as well as Russia. So there are same rules to confidentiality when working remotely as there would be in case of working in the employer's location. So obviously, since the working environment is different, the employer may need to establish separate rules for various practicalities, such as not having phone calls in the presence of third parties, not printing out documents, not leaving the computer unattended, or providing access to third parties. There's again no special regulation on how to monitor the working time of remote employees, and basically the same regular rule applies, that it's the employer who has to keep working time records. So it's usually not much of an issue if it's a regular hours, 8 hours per day, 40 hours per week, but if the remote working is also combined with flexible working time, then the only solution may be to request the employee themselves to keep the records. The new challenges that have showed up in practice in connection with this remote work and working time is that some of the employees tend to wish to work from abroad, from different locations, either because they are coming from such countries or because they have transferred, and then it might be an issue to combine online meetings with the time zones where the employees are located, and this has to be taken into consideration. Then obviously there's also the issue of the working hours versus output that is achieved, and there's no sort of a magic solution there, but depending on the type of work, additional reporting obligations may be needed in order to have an idea of what the employee is doing and is engaging in during the remote working hours. These were the remarks for Estonia, and I'm passing on to Jovita in Lithuania.
Yes, so although work is being organized from home, GDPR has not gone anywhere, and it is still applicable and especially important in the times of pandemic. So we have noticed that the employers during the pandemic lean towards collecting more sensitive data of the employees, and especially something that relates to their health. This can be done, and this should be done very, very carefully. And first of all, privacy policy should be reviewed, and the employees should be presented the reviewed versions of the privacy policies. So if you are trying to collect data that was not previously collected, then first of all, first step is to update the privacy policy. Perhaps you have heard that recently H&M has received a huge fine of 35 million euro for breaching GDPR, so that we can see that the consequences may be actually quite hurtful for the company. When it comes to the right to disconnect, the employer should create an environment in which the employee has the right to disconnect from work and should not receive any work-related assignments. And this can be done in a number of ways. So promoting the culture where work stops at a specific hour, or actually physically blocking emails after a specific time. When it comes to confidentiality, the employers should also set out the requirements for remote workplaces. And this is done in order to ensure employers' safety, so the safety of the employer's information. Such requirements may include secure internet connection, the use of passwords, and etc. And then the employer should also provide the rules on how confidential information and documents should be used and shared. So using only secure sharing channels should be promoted. Only encrypted emails or similar type of security levels should be included, because we have heard stories where documents are shared via Facebook chat and so on. This should not be a regular occurrence in working setting. In Lithuania, the employee is responsible for recording his own working time at home. Of course, the employer may check and verify whether the employee was actually working or not, but the general rule is that the employee should keep his own or her own working records. Now, promotion of healthy working environment and fixed working hours actually here comes to full circle, because if not, that is not promoted, most probably the employees may provide working records where overtime will be in excess. So this is all from Lithuania, and now let's go to Poland.
Well, it seems that Polish regulations do not differ much. What should be stressed in terms of privacy is that employees basically have the same confidentiality obligations when working from home or working in the office, but obviously the risks are higher. An employer can assure privacy at home by, for example, providing companies properly secured equipment. Using of such equipment should be a rule, and transfer of data to private computers should be banned. Also, rules on confidentiality should be set, as already mentioned in other countries. For example, a rule that the computer cannot be left unattended, or a clean desk rule. Training of employees is also very important. Employees should know, for example, to whom report any technical problems, or what to do in case of theft, robbery, property damage, and data loss. And in terms of working time records, employers have a general obligation to record all working time of employees, whether working in the office or remotely. However, they may require employees to keep records of activities and time spent on them. And based on such employees' records, employers can later prepare their own working time records required by law. This may obviously limit the overtime claims as well, which are actually quite often in case of remote work due to limited control of employer over employees' work. Thank you, and I'm handing over to Daria for the last time.
Yes, Dita, thank you. The last but not the least, I would also say that there is no special privacy, confidentiality, or reporting rules for remote employees established by law in Belarus. So that's why the companies are free to maintain its own procedures, both technical procedures and surely legal policies. And here I would also recommend and support all these ideas and insights that my colleagues shared from European jurisdiction. They all may be implemented in Belarus as well. So to introduce internal policies, how to process data, how to keep the commercial secrets, because employees, remote employees, are also subject to the general rules on commercial secrets in Belarus too. if we speak about the working hours and rest time, so remote working employees are subject to the general rules as well. But unlike in Lithuania, for instance, in Belarus, employers themselves have a general obligation to record all employees' working time by themselves. So that's why surely companies should think about special procedures, maybe CRM systems or any other special obligations on reports that they may introduce to such remote workers. In practice, to control the working time, companies sometimes introduce certain duties, certain special duties for employees limited by the clear time frames. For instance, they require employees stay online from 9 till 6, or they require video communication or text messages in corporate chats, or report in writing to the at a certain time period. So everything depends on the internal corporate rules and the task that these employees are fulfilled. So I guess it's all from my part regarding Belarus, and generally we are ready to move to Q&A session. And so Alex, we have several questions from our audience, and we have like 10 minutes or 8 minutes, and I would also encourage our participants to ask questions, and if we are not covering them right now, so we will definitely come back to you via emails and take the questions. So we have a question which is not specifically per any jurisdiction. It relates to insurance, working accident insurance. So if we offer possibility to work from home in a structural way, like 1 or 2 days per week, is working accident insurance extended when working from home? More specifically, are the employees covered by working accident insurance if an accident occurs while working at home, or it's a separate coverage to be implemented? So, Alex, if anyone from you is ready to take this question right now, or if you do not need any special consultation, so please, you're welcome.
So I can start answering this question. In Lithuania, actually, the insurance covers even accidents which happen at home. But this professional risk assessment is very important. So if the employer has performed professional risk assessment, or the employee performed this assessment by himself or herself, and then this accident falls into the accidents which are covered by the insurance, then the insurance claim will be satisfied. And usually, what type of accident is covered by the insurance? So when the employee was following all the rules, but something just happened. So for example, something fell or on his head, or there was a similar accident which occurred. But if the employee is not following the rules, or the employer has not set up proper rules, then this type of accident will not be covered. So in Lithuania, no additional insurance is required.
Yeah, from Russian perspective, I would add this is same. No special insurance is required, because employers are covering by social insurance contributions, are providing this mandatory state insurance both to remote employees and those who work in the office.
So, okay, I think we can, so from Belarusian side, I would say that we don't have quite a lot relevant practice on that aspect, but I would also say that no separate insurance is required, because we, as in Russia, we're also covered by social security payments and insurances, but surely maybe practice will go on some other way. So let's see. But as of now, I would also support the idea that no separate insurance. Toms, we have one question for Latvia regarding the amendments that will be adopted in the coming months, allowing the parties to agree that in the case of remote work, expenses should be covered by the employer. Can you please share the link to those amendments or comment or?
Sure, maybe the person asking the question can drop me an email and I will send the link by email.
Okay, then I hope the participant hears us now and will send you an email. And we have 1 minute, and maybe colleagues, let's discuss such very short question. Remote work from abroad. Haley touched it a bit, but what do you think? Is it allowed in your jurisdictions? If the employee stays not at home, but somewhere in Bahamas or at his home country, is it okay to establish a remote work regime with such employee currently staying outside the country?
Yeah, for Latvia, it's allowed, but of course you have to take into consideration potential taxation implications. So depending on the duration of the remote work from abroad, there could even be a situation that a permanent establishment for tax purposes is created abroad for the employer. And there could also be certain implications for the employee himself or herself. So it has to be carefully evaluated.
Yes, and in practice, there's also always an issue of the resident permit for work or other work-related permits if the person is going to a country which is not the country of citizenship, or if it's outside the EU. So, for example, in Estonia, there would be a special type of visa available to such employees wishing to relocate here. It's a relatively novel thing, but it's called a DigiNomad visa. So it's basically for the people who could work from anywhere from the world. So they can apply for that and transfer. But depending on where the employees would go, these kind of issues also need to be considered in addition to the tax matters mentioned by Toms.
It's actually similar in Poland. So although it is legally required to work from abroad, we of course should take into consideration all those problems that have already been mentioned, and also the problem of applicable law when an employee is constantly performing work from another country. And actually in Poland, due to all of those issues, employers rather avoid allowing employees to work from abroad. They usually require that the work should be performed from the territory of Poland.
And the same goes for Lithuania. The issues that have been mentioned also applies to personal income tax, permanent establishment, and so on. Those issues can be created if the employee is working from abroad. So usually, as in Poland, the employers do not allow working from abroad.
The position in Russia is actually that remote work with employees abroad is not possible because the employer is not able to ensure health and safety rules if employee is located abroad. So that's not possible in Russia.
So interesting. Thank you, colleagues, for sharing. In Belarus, I would say that it's possible, and due to political turbulent situation that we're having now, relocation and personal relocation is in trend, and the position of our regulator and many companies that it is okay, but the employee is subject to local labor law regulations. The Belarusian law shall be applicable to all employment relations, but I would also support the idea that the tax circumstances of such relocation shall be taken into account. Okay, thank you, colleagues. Thank you for your participation and answers. And so please, Annie, the floor is yours for closing remarks.
Thank you, Daria. Finally, I would like to thank everybody for attending, and thanks also to our presenters for their insights. So with that, this webinar will now be ending. Thank you all.